Patent appeal versus continuation. Which is the better path after a final rejection? Let's dive right into this critical decision. Navigating patent prosecution can be complex, especially after receiving a final office action. Knowing your options is key. The core dilemma is how to respond when your patent application faces a final rejection. You typically have two primary routes. First, let's clarify what a final rejection means in the context of the US PTO examination process. A final rejection indicates that the examiner believes the application is ready for appeal, or further prosecution requires a request for continued examination. Your choices are to pursue an administrative appeal to the Patent Trial and Appeal Board, or file a continuation application to reopen prosecution. Choosing the appeal path is a direct legal challenge to the examiner's decision, focusing on errors of law or fact. This strategy involves filing a notice of appeal, followed by a formal written brief detailing why the examiner's rejection is incorrect. The main benefit of an appeal is the potential for a direct and definitive reversal if the examiner made a clear legal or factual mistake. However, appeals are costly, time-consuming, and carry the risk of a final, unfavorable decision with little opportunity for amendment. The alternative path is the continuation application, which focuses on re-engaging with the examiner. This involves filing a request for continued examination, or RCE, or a new continuation application to reopen prosecution. A continuation allows you to introduce new arguments, evidence, or amend claims, offering flexibility not available during an appeal. The downside is the added expense of new filing fees and potentially prolonging the examination process. Now, let's compare these two options to help you determine the best fit for your specific situation. An appeal is typically warranted when the examiner's rejection is based on a clear error of law or fact, and you believe your claims are fully supported. A continuation is best when you need to make claim amendments, introduce new evidence, or simply haven't exhausted all persuasive arguments with the examiner. Ultimately, the strategic recommendation depends heavily on several factors unique to your application. Consider the scope of your claims, your budget constraints, and the time sensitivity of obtaining the patent when making your decision. Both appeal and continuation are viable routes, but they serve different strategic purposes in patent prosecution. Always consult with experienced intellectual property counsel to analyze your specific case and choose the path that maximizes your chances of success.